Right, so we just wait another minute or so for people to jump on here. I like my new theme music I have. All right. All right, well, we'll go ahead and get started. So, welcome to the Legal Table. I'm your host, Crystal Jamerson, and I'm the Community Engagement and Outreach Coordinator for Legal Services of Northwest Minnesota. The Legal Table was created to educate you on your rights and responsibilities, along with introduce you to community organizations that have resources to help you along the way. Today, we are here to address fair housing and resources you can use to assist you. As you know, housing discrimination can take on many forms. So today we learn about what fair housing is and what you can do if you or someone you know is treated unfairly when looking to rent, buy, finance a home or a place. So today, Legal Services of Northwest Minnesota is trying to make sure that people in our counties that we serve are aware of the process and the resources that are available. As you know, Legal Services of Northwest Minnesota, we serve 22 counties. We have 3 offices in the area where we assist clients in navigating the justice system, and we provide services for low-income individuals in the area with civil legal needs. We hope to bring you some more information on many civil legal topics throughout the year. So make sure you continue to join us and pass the information along to coworkers and to clients. With that being said, I want to introduce you to our guest today. Our first guest is Sarah Moore. She is an LSNM staff attorney. Then we have Michelle, and it's Reeds from High Plains Fair Housing. And then we have Mary Rhea from Legal Services State Support. Real quick, just a few housekeeping rules. Please make sure to put all of your questions in the chat, and we'll get to them at the end of the presentation. Also, this is a quick hour-long meeting, so if you would like more information, each panelist will have their information listed at the end for more info. This information will also be available on our YouTube channel by the end of the week. So if you have coworkers that were unable to make it, please make sure to check out our channel. Without further ado, we are going to turn the mic over to Sarah from our LSNM office.
All right, well, good afternoon, everybody. If for some reason you can't hear me, please do a hand raise or let me know. I tend to have a loud speaking voice, so it's not usually an issue, but if there's any technical difficulties, please let me know. As Crystal said, my name is Sarah Moore. I'm the managing attorney in our program's Alexandria office. I've been with Legal Services for over 20 years. And have practiced in multiple different areas. But now I am our program's housing lead and practice a good majority of what I do is in the housing area, both public and private housing. But the topic today is fair housing, housing discrimination. And so I thought I'd start a little bit with the definition or where it comes from. The Federal Fair Housing Act is, what was developed to address these issues, providing fair housing to everyone, prohibiting discrimination to individuals when they are renting or buying a home, when they're getting a mortgage, when they're seeking housing assistance, or engaging in other housing related activities. I know a lot of times I talk to clients that mention something that they don't like about their housing, or they feel that they've generally been treated poorly, and they automatically use, I've been discriminated against. But keep in mind that discrimination is a legal concept and applies only to certain protected classes. And so when the Fair Housing Act, when it talks about discrimination, it addresses discrimination based on race, color, national origin, religion, sex, which includes gender identity and sexual orientation, familial status, and disability. And so you need to, if there's discrimination, you need to fall into one of those categories. Um, so the Fair Housing Act covers most housing. There are a few limitations. The primary one that we see being housing that is owner occupied. So if you're looking to rent a room in an owner occupied home, then there are some limitations on that. And that owner can treat certain individuals differently when they are also occupying the home. Also, housing operated by religious organizations and private clubs that limit occupancy to their members. There are some exceptions to the discrimination. But otherwise, in the most housing that we see, private rental housing, public housing, discrimination, and those categories that I mentioned apply. So what is prohibited? What is prohibited under the Federal Fair Housing Act in public and private housing? Landlords or homeowners cannot refuse to rent or sell housing. They cannot refuse to negotiate for housing. They cannot otherwise make housing unavailable. They cannot set different terms, conditions, or privileges for sale or rental of a dwelling. They cannot provide a person with different housing services or facilities. They cannot falsely deny that housing is available for inspection, sale, or rental. They cannot make, print, or publish any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination. They cannot impose different sale prices or rental charges. They cannot use different qualification criteria or applications or sale or rental standards, such as income standards, application requirements, application fees, credit analysis, sale or rental approval procedures, or other requirements. They cannot evict a tenant or tenant's guest. They cannot harass a person. They cannot fail or delay performance of maintenance or repairs. They cannot limit privileges, services, or facilities of a dwelling. They cannot discourage the purchase or rental of a dwelling. They cannot assign a person to a particular building or neighborhood or section of a building or section of a neighborhood. And they cannot refuse to provide or discriminate in the terms of condition of homeowners insurance. And they cannot deny access to or membership in multiple listing service or real estate brokers organizations. So, I mean, that covers obviously a wide variety of things. But these are things landlords and homeowners cannot do and cannot treat people differently based on the categories that I listed previously. Now, that's a very long list. I can tell you that most of the things that our organization sees come up in that disability category when we are looking at rental properties and landlords that may be refusing to provide reasonable accommodations or modifications based on a disability. We also unfortunately do see people that are discriminated against based on race or color. We see that unfortunately frequently, but there are systems set up where we are not, in those cases, our program is generally advising. We may refer people to the Minnesota Department of Human Rights. We may refer people to HUD, which stands for Housing and Urban Development Agency, to make complaints through their complaint process. Where we get a little bit more hands-on at Legal Services has to do, again, in that disability category. We have clients that contact us because they feel that they need a reasonable accommodation or a reasonable modification in their housing because of their disability. And so we will, if the client qualifies, we will often get involved in contacting a landlord and helping with that reasonable accommodation process. And so a reasonable accommodation makes it, let me back up. The Federal Fair Housing Act makes it um, unlawful for any person to refuse to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford persons with disabilities equal opportunity to use and enjoy a dwelling. The act also prohibits housing providers from refusing residency to persons with disabilities or placing conditions on their residency because those persons may require reasonable accommodations at some point in the future. So who must comply with these Federal Fair Housing Act reasonable accommodations requirements? Any person or entity engaging in prohibited conduct, like refusing to make reasonable accommodations and rules, policies, practices, or services necessary to afford a person an equal opportunity to use and enjoy a dwelling, may be held liable. So, I mean, this is landlords, property management companies, individual property managers, real estate agents, homeowners associations. Those are all people that could be held liable if they are unwilling to make a reasonable accommodation to an individual with a disability. So disability under the Federal Fair Housing Act is defined as a person with a physical or mental impairment that substantially limits one or more major life activities, and individuals who are regarded as having such an impairment, and individuals with a record of such impairment. So there is some qualifications and requirements that an individual needs to provide. Obviously, if their disability is obvious, then the landlord or property manager cannot ask for additional documentation from that person. But if it's something that's not obvious, an additional documentation may be necessary. And so, and when I talk about reasonable accommodations, again, we're looking mainly at rental property. So it's not just in the rental unit itself, but also in common areas of the building, in the public and common spaces. I think I saw a question pop up about PowerPoint. I do not have any PowerPoint slides, but I certainly am willing to repeat information or answer questions if people have them. So there are some instances when a reasonable accommodation can be denied. That would be if the request was not made by or on behalf of a person with a disability, or if there is no disability related need for the accommodation. And additionally, a reasonable accommodation may be denied if a person if the providing the accommodation is not reasonable. For example, if it would impose an undue financial or administrative burden on the housing provider, or if it would fundamentally alter the nature of the provider's operations. When there are reasonable accommodations, there is no need for, or housing providers cannot charge extra fees or deposits as a condition of receiving the accommodation. The most common example we see of this is if someone is requesting an emotional support animal as a reasonable accommodation in a building that does not allow pets or does not allow multiple pets. The landlord cannot charge extra fees for that pet, cannot charge a pet deposit or things of that nature for that emotional support animal, because under the law, that animal really isn't considered to be a pet. You know, again, like I said before, we get involved because it doesn't need to be assumed by a landlord or a property manager that an accommodation is necessary. It does need to be requested. So the person that wants it does need to request it. And we often can assist individuals in making that request. Oftentimes it just involves a short letter from one of our attorneys that helps with the accommodation. Or there are times when the accommodation might be denied for unreasonable reasons, and we could get involved possibly in litigating that issue. Um, and so the other topic I wanted to just very quickly cover is there is the difference when it comes to modifications, a reasonable modification. And you can kind of guess just by the description, but a modification involves more of an alteration and structural changes to the interior, exterior of a dwelling or common areas. For instance, widening doorways for wheelchairs, installing grab bars in bathrooms, lowering kitchen cabinets, adding a ramp, altering a walkway. Those would be considered modifications, not accommodations. Accommodations, like I said before, apply more towards rules and policies, where a modification applies more to a physical change in a structure. Again, it's the same thing. Individuals with disabilities that substantially limit a major life activity would qualify for a modification. Um, and again, it does need to be reasonable. Um, there does need to be an identifiable connection or nexus between the requested modification and the individual's disability. If no such nexus exists, then the housing provider may refuse to allow the requested modification. Um, a housing provider, both when I'm talking about accommodations and modifications, a housing provider may not ordinarily inquire as to the nature and severity of an individual's disability. However, they may request information that is necessary to verify that the person meets the Fair Housing Act's definition of disability, describes the needed modification, and shows a relationship between the person's disability and the need for the requested modification. And so that information can be requested and the person needs to provide it. Again, as I mentioned before, if the person's disability is obvious, then and the need for the modification is readily apparent or known. For instance, if a person is in a wheelchair, it's going to be readily apparent that they may need a wider doorway. Then there isn't the ability to ask for additional information. So generally when you're thinking, okay, physical changes to a structure, there's maybe significant costs involved in that. Generally, under the Fair Housing Act, the housing provider is the one responsible for the costs associated with a reasonable accommodation or modification, unless it is an undue financial and administrative burden. While the tenant or the tenant or someone acting on the tenant's behalf may then be responsible for costs of that modification. I thought about going into more detail when we're talking about, because this topic comes up every time I do a housing presentation, talking a little bit more about the emotional support animals and service animals. It's unbelievable how many times those questions are asked recently. And I felt like that might even be an entirely separate topic for a one of these trainings in the future. So I am kind of going to shy away from that. And I thought I would focus more on the disability and the reasonable accommodations and modifications. But certainly if someone has a question related to that, I'd be happy to answer it. But I think at this point, I mean, I think we can include Miss Rids in the discussion. And then if there are things that maybe we can come back around to, I'd be happy to do that.
All right. Thank you so much, Sarah. There's a lot of information that I wasn't even aware of when it comes to fair housing. And we did get a couple of questions that had popped in. So we'll definitely take those at the end so that you can get that all taken care of and everybody has some time to present. But um, it's amazing the type of cases that we do get here at LSNM in regards to fair housing. As I've gone through some of the reports, it's astounding how many of those come in and why it's important that we do have many attorneys that are just their specifications are in housing to be able to deal with that because the amount is just jumping up. So um, thank you so much, Sarah. We're going to go ahead and move on to Michelle. Michelle is from High Plains. Sorry, I'm Michelle is from High Plains. Thank you so much for coming on today.
Yeah, you bet. Some of this stuff I'm afraid will be repetitive, but I think that's probably good. And I agree with you that emotional support animals, service animals, therapeutic animals, assistance animals is a topic that is a big topic and can be definitely a whole hour, if not more. High Plains Fair Housing Center is a private nonprofit organization. We were founded about 10 years ago, and we're based in Grand Forks. Most of the work we do is in North Dakota. However, we I have had some cases in Minnesota, and we certainly, if you're somebody who needs advice or how to, maybe perfect a complaint, we can help you. Certainly feel free to call us, and I'll give you our information, and I already did in the chat. None of us are lawyers. We are, oops, it didn't forward, figures. Okay. We're not lawyers. We're advocates working for the Federal Fair Housing Act. We have three main things. We do education and outreach, so letting people know what their rights and responsibilities are under the Federal Fair Housing Act. And we do enforcement, so we investigate, and I'll talk a little bit more about that, instances of housing discrimination. We try to identify evidence to help support people who may be experiencing housing discrimination. And then we do advocacy. So we assist people who believe that they've been victims of discrimination through mediation, not the legal sense of mediation, just working with the landlord and trying to come to resolution. Or helping people through the complaint process or through the court process. And we work with attorneys in that case. So how our advocacy works, our advocacy works is that people will call us, and if they have a specific concern, our intake staff will discuss the situation with them over the phone, determine whether there's evidence of a fair housing issue. The call is confidential, and High Plains doesn't take any action unless a client requests us to. It is, of course, helpful to have as much direct or hard evidence as possible. So that's emails, texts, any kind of recordings. In North Dakota, we're a single party recording state. So we always advise clients if they're not able to write down or have an exchange in email to tape record their with their phones. And then we advocate, with the housing providers. We'll talk to them about what we see. We'll talk to them about the law. We'll educate the housing provider on what's happening. And when possible, we try to find a solution. If there's evidence of discrimination and the issue can't be addressed through this kind of mediation, we will work with the client to file a complaint with HUD. And in our case, the North Dakota Department of Labor and Human Rights. The North Dakota Department of Labor and Human Rights, or HUD, or Minnesota Human Rights will investigate the claim. They're impartial enforcers of the Fair Housing Act, and so they'll do the investigation. They'll work all along to try to come to a conciliation because they want to resolve the case before it gets to an issue of, before litigation. The investigator will determine whether or not there's reasonable cause to believe discrimination occurred. And if so, the department will charge discrimination. In the conciliation, there's a couple of different remedies. It can be a monetary remedy. It can be remedies in the public interest, such as, making sure that everyone at the company, at the rental company, knows what the Fair Housing Act is, goes to fair housing training, and make sure that all the tenants in the buildings know what their fair housing rights are. So putting posters up, passing out materials, that kind of thing. So usually the conciliations, in addition to getting the remedy that they want, whether it's the reasonable accommodation that they want, there could be monetary compensation as well as the remedies in the public interest. Our education and outreach, like I said, pretty straightforward. We do a lot of workshops. We're at booths. We talk at churches a lot, just letting people know what their rights are under the Fair Housing Act. And then conversely, we offer, CEE credits for real estate agents. We work with lawyers to try to deepen the civil rights bench in North Dakota and the surrounding areas. When we have a lot of publications in a lot of languages, so I did put our website out there, and you can see all the variety of languages that we have our materials in. And then we do our testing program is our secret shopper program, which is basically using testers to gather objective evidence to investigate housing discrimination. So that's somebody from a protected class and not from a protected class, simulating a rental or sales or lending experience, and then using that evidence to either file organizational complaints or to help bolster a complaint for somebody who might be experiencing housing discrimination and just doesn't have enough hard evidence on their own. And then we do, pattern and practice investigations. So looking at large housing providers and determining if they have blanket policies that could be discriminatory. We do a lot of, demographic data, looking at trends. If you're in the Moorhead-Fargo area, we have a lot of data that demonstrates that in the last 10 years, we've seen Fargo go from a pretty, homogenous community to a very diverse community. And during that process, we went from pretty integrated throughout the city to now some majority minority census tracts. So we're seeing Fargo kind of trend into Fargo Moorhead areas kind of trend into resegregation. And so those are the kinds of things that we look at. As was already mentioned, our federally protected classes are race, color, religion, sex, including sexual orientation and gender identity, familial status, disability, which is any physical or mental impairment that substantially limits one or more major life activities. Additional state protected classes in Minnesota and North Dakota include public assistance, age, marital status. In North Dakota only, we have certain protections for victims of domestic violence, allowing victims of domestic violence to get out of their lease earlier. And then we have in Minnesota only sexual orientation and gender identity, which of course has been expanded through the federal law currently. So what is housing discrimination? We've talked about this: blocking someone's access to housing, treating somebody differently, denying somebody a right to buy or rent a home. And I'll give you some examples as we kind of, well, first I'll talk about the two theories of discrimination. Disparate treatment, we understand. Basically, disparate treatment is somebody is treated differently based on their protected characteristics. And disparate impact is when there is a rule that seems on the face neutral, but in fact has a discriminatory intent. So some landlords, I think in Minnesota, there was a city that was recently sued, has nuisance ordinances. The nuisance ordinances are a nuisance in their lease, nuisance clause. If somebody calls a landlord more than 3 times, I'm sorry, somebody calls 911 more than 3 times, then they are penalized or they may lose their housing. And so what that happens is that has a disparate impact on people who have a disability. So somebody who may have seizure disorder and may have to call a ambulance. They have to decide, or their, a loved one has to decide, do I call the ambulance and risk losing housing? But their health and safety is involved. This also impacts women who 98% of the time are victims of domestic violence. This could be sex discrimination, because if they are choosing between their safety and calling 911, that could have, a lasting impact. So that's, disparate impact. National origin discrimination. So what does that look like? Native Americans can fall under national origin discrimination as well as race discrimination. So that means differing rent or deposit prices. We had a fair housing testing case where somebody from another country was one of our testers, and he was told by the landlord that if he wanted to view the apartment, that he had to pay an application fee. Whereas our white tester was not told that. So that's a perfect example of national origin discrimination, where somebody is treated differently in the application process. Steering or restricting persons to one area of a building or a complex. Another case of national origin discrimination, this happened in Fargo, where a tester was actually there testing on disability-related discrimination, but the housing provider started to say, "Do you see how nice our building is? Our building is so nice, and that's because we don't rent to anyone from another country in this building. We have them all in a different building across town." And so our tester was, kind of floored, not expecting to hear that. The person went on to continue saying that, this is such a nice building, and we'd keep it that way because there's nobody from foreign countries living here. So we definitely filed a fair housing complaint on that one. Harassment about food odors. We've actually seen in leases where they kind of state very blatantly that, food odors, exotic food odors are not allowed. That could be fair housing discrimination based on national origin. So, some of the things that are a bit harder, like owners who make repairs for one group of tenants over another, it's harder to prove, but that could be national origin discrimination. We talked a little bit about disability before. Deny housing based on disability. Another case that happened in the Fargo-Moorhead area, where a gentleman was in a wheelchair, called up for a vacancy of a unit, and asked if he could, take a look at it. They said, absolutely, come take a look at it. It's open. And as soon as the gentleman got to the unit, just maybe 20 minutes or so, the man saw he was in a wheelchair and said, "Oh, between now, I didn't realize my wife had already rented it out." And so this man in a wheelchair went back to his home, talked to his sister about it, and his sister called up to see if the vacancy was still there. And so they did their own sort of, their own testing, and discovered that, in fact, it was there. So that man filed a fair housing complaint. And then intimidation and harassment. Sadly, we see a lot of that. We see a lot of tenants and sometimes housing providers, but a lot of times tenant-on-tenant harassment based on disability, especially for individuals with developmental disabilities. Zoning ordinance, another thing is to keep an eye on. If you're seeing that group homes are being denied, that could be a violation of the Fair Housing Act. And then another examples of unlawful discrimination is refusal to make reasonable accommodations. Over 50% of all fair housing claims, calls, intakes are reasonable accommodations. And then finally, just a brief comment on sexual harassment in housing. Had a couple of big cases in Minnesota related to this, but it can take the form of unwelcome sexual advances, requests for sexual favors, or other forms of physical or verbal abuse of the sexual nature. It could be something like quid pro quo, where, you know, a landlord or or a property a housing provider says, hey, you know, send me a picture and I'll, you know, knock off some money on your rent. Even if the act is acquiesced to, even if if it happens, it's still a violation of the Fair Housing Act, and it still can be litigated and go to needs to be litigated. Oops. And then just one, you know, this is just a recent case that we had. This is, I always like to start off by saying this case should never have happened. This housing provider, this happened in North Dakota. This housing provider received federal funding. This was a family of 6 in a 3-bedroom, 1,500 square foot townhome. When they announced the birth of their 6th child, they were non-renewed, or their 5th child. So it was a family, 4th child, a family of 6 anyway, 3 bedrooms. And when they announced the birth of the child, they were non-renewed. And the housing provider stated that they had an occupancy limit of 1.5 people per bedroom. So I don't know how they got the half person, but they did. That was what their rule was. So this family had never been late on rent. There was no occupancy, you know, issues, you know, in ordinances in the city. So it was, you know, rather surprising. High Plains advocated, and we advocated a lot because, you know, we knew that they got federal funding. So they knew that they had a special, you know, obligation to affirmatively further fair housing and to, you know, follow the Fair Housing Act. And so, you know, we advocated and we wrote to the board members, and it failed. Our advocacy failed, and so we filed a complaint. This settlement came through a HUD complaint, so it wasn't even a court case, and the client prevailed, obviously. So that was a speed presentation of the Fair Housing Act. We have a lot of resources, a lot of events, a lot of online events if you want to know more. I also have the HUD FHEO information there. So with that, I will stop sharing.
Thank you so much, Michelle. I know it's a lot of information in a little amount of time, but hopefully everybody was able to grab the contact information. And if not, I do have some of the basic information at the end, and you can always contact me for more information about Michelle. And there are some more questions that are coming in. We will save those to the end. So really excited that they're coming in. If you do have questions, feel free to throw those in the chat too, so that we can make sure that all of our panelists have an opportunity to see all of the questions. And with that, we are going to move on to Mary from Legal Services State Support.
Thanks, Crystal. I'm Mary Ray with Legal Services State Support, and I'm here to talk to everybody today a little bit about the resources that are available on lawhelpmn.org. And a lot of those resources echo what both Sarah and Michelle talked to you about this afternoon. I'm going to go ahead and share my screen, and we can take a look at the website. Some of you may have seen it before. Let me just see, am I showing?
Yep.
Okay, excellent. Okay, so this is the homepage of lawhelpmn.org. Our website, for those who are not familiar with it, is open to, it's a statewide website, and the laws included are for Minnesota specifically. So if you're looking at our website from another state, just know that your case or your legal issue will need to be in Minnesota for the information, documents, and laws and providers that are available on the site are for Minnesota specifically. So today we're going to look at our self-help library. So if you just click on this link and browse down, you'll see that we have several sections, main topics for civil legal problems or issues that one might have in Minnesota. So we're going to look at housing today, since we're talking about fair housing, and these tiles represent the subtopics under housing. So the two that are going to apply to our topic today are going to be the housing discrimination tile and the reasonable accommodations tile. So I've got those pulled up. I'm just going to take a quick look at housing discrimination. So under the housing discrimination tile, you'll see that we have 4 fact sheets, and we also have some other resources at the bottom, such as our Tenants' Rights in Minnesota booklet, which will have sections available on fair housing, discrimination in housing, etc. For the purposes of this topic, though, under housing discrimination, one that I want to call your attention to is our main fact sheet on housing discrimination. This is available in English, Spanish, English, Spanish, Hmong, and Somali. And these fact sheets are updated every year by legal professionals. So you know that the information that you're getting is from legal aid lawyers like Sarah, who look at our fact sheets every year and make sure that they're up to date. So this kind of goes over some of the things that both Michelle and Sarah were talking about, such as what kinds of discrimination is illegal, signs of possible discrimination, and then references to other fact sheets. Also, if you think you are being discriminated against, what can I do about it? There's a section there. And of course, we encourage you to contact a legal professional or an organization like Michelle's. And then for lawsuits and agency complaints, there's some information under that tab as well. Also on the left-hand side, we have a section in each of our fact sheets of other resources that you might find useful. I know that Sarah mentioned a lot of emotional support animals and reasonable accommodation. So that's something else that you can look at. And then you can also open this fact sheet as a PDF if that's something that you wanted to print out for yourself or to share with other folks. So I'm just going to back up really quick and go over to back to browsing self-help, looking at housing again. So that was the stuff that's under housing discrimination. I want to call your attention specifically to the reasonable accommodations tile, which also includes the discrimination fact sheet we just looked at, but has a little bit more information than the other tile, because this one also includes reasonable accommodations. Do you need your landlord to make a change because of your disability fact sheet, a fact sheet on fair housing for older adults with disabilities, and can I keep a pet, which talks about that emotional support pet and other types of pets for those with living with disabilities. So the reasonable accommodations fact sheet, again, questions about some examples of reasonable accommodation, if you can ask for changes in your home or apartment or rental for reasonable accommodations, and what to do if your landlord is not giving you a reasonable accommodation. And so then there's some information here about who you can contact. And also that service and emotion support animals at the Minnesota Department of Human Rights. We have a link out to that too. So there's other agencies that we link out to on Law Help, which is really great. Just backing up, I want to show that we also have fair housing for older adults with disabilities fact sheet, and specifically questions about who qualifies as disabled and protections for disabled seniors. These fact sheets are all available in the 4 languages: Somali, Hmong, Spanish, and English. And then I think there was one I wanted to show you. Oh, yes, can I keep a pet? And can I keep a pet goes into the specifics about being in public or subsidized housing with a pet, service animals, and emotional support animals. So I hope that people will, take a look at this. And if you have any questions, really explore these. Again, under the main housing topic for discrimination and fair housing, you're going to want to look at housing discrimination tab and also reasonable accommodation to get most of the information that we have on Law Help. So I'm just going to stop sharing really quick. I think that took my screen away. I hope. Maybe not. Did it?
Not
Nope.
yet. Not yet.
Not yet. Okay. There we
Oh,
go.
there we go.
All right. Thank you so much. And thank you to the other two trainers. That was a really, both of your presentations were very helpful. Um, so
Definitely. No, thank you so much, Mary. I always love having Mary on because she knows exactly where to go on Law Help MN, and I'm sitting there taking a couple of minutes, but she's right on Johnny on the spot. So thank you. I
you're
appreciate that.
welcome.
So what we're going to do is take some time really quick because I do want to try to keep it within the 1 hour to take some of the questions and have some of our panelists answer some questions. And then I actually have a cool new little feature called Community Choice. And so we'll be able to do that right before we're done today. So the first question that I had that had come in was, and I believe this one, anybody can take it, but I believe this one was directed for Michelle. If they get a police call for domestic violence to an apartment, can the landlord evict them for a police call?
Right. So it could be under the, and of course, there's a lawyer on the on the call too. So I'd like her to weigh in too. But so it could be a disparate impact claim as an advocacy organization. What we would do is probably talk about that could be a violation of the Fair Housing Act. They shouldn't get evicted for a call based on domestic violence, but we have seen both cases of people with disability and domestic violence being threatened with eviction. And then we've had to advocate and get that kind of stopped. And based on disparate impact, and impact claims are difficult to prove, but those are pretty straightforward ones.
No, thank you for that.
And then, oh, sorry, Crystal.
No, go ahead, Sarah. Jump on
I
in.
was just gonna hop on that. I mean, specific, this is kind of outside of like I mean, obviously there are the impacts with, fair housing, but also in Minnesota, there is the state law or the state statute that protects people in rental housing, their right to seek police and emergency assistance. If you want to write that down, there's Minnesota statute 504B.205. So that, it permits, people to make emergency calls for situations of domestic abuse or other emergencies that they might have. And the landlord cannot bar or limit that right. They can't say, I think it was previously discussed, you only get you get like 3 or whatever. They can't bar or limit it. They cannot impose a penalty, and they cannot terminate their lease. And a lease cannot add in a provision saying you only get this many or your lease might be terminated. So a tenant cannot waive that law in Minnesota. So in sometimes there are local ordinances, but generally the statute is that there cannot be a limitation or a penalty on seeking police or other emergency services.
No, that's really good to know. And you did bring up leases. And so that brings us to a different question, Sarah, while we're on you. If they won't make an accommodation, can you break your lease? So if they don't make that accommodation, or how would you go about that?
I mean, I think maybe Michelle was going to answer too. I think a little bit. It depends. I mean, I would kind of have to know on the circumstances. I mean, in most cases, I would say that rises to the level of discrimination based on disability. If you've done all the other things, provided the necessary information, the connection to your disability, you've done all those things, and the landlords won't do it. I would say that it might be a basis to break your lease, but I would also, contact our agency or other agencies or file the complaint. Try those steps first before you're looking at breaking your lease.
And yes, that is we've had a lot of cases where people have wanted to break their lease for whatever reason, and that usually, they can break their lease within reason. So they might have to pay one, month's rent or something like that. And because there's a lot of times where they just can't. Conversely, I think like what Sarah was alluding to, we've had, somebody ask for a reasonable modification and they said, no, you can break your lease. And the client was like, I don't want to leave. I'm in a wheelchair. I'm here, but I need a modification. And so then we ended up filing a federal lawsuit because they just would not do the reasonable accommodation or reasonable modification. They just kept on saying, no, just break your lease, just leave, which is not good either. But yes, we've had several cases of letting people wanting to break their lease because the reasonable modification just wasn't working out for them.
No, that's good to know. And it looks like Mary had also put in some really nice information into the chat. So if you guys want to swing into the chat, she has 2 links in there. The first one, it looks like a tenant's right to call for help, which was helping to address that issue in regards to the police call for domestic violence. And the other one was the reasonable accommodations. Do you need your landlord to make a change because of your disability? And that's on Law Help Minnesota. So that's awesome. Thank you so much, Mary, for putting those in there. We have 2 more questions. It's the next one is can people can people call in to see if someone can put a tester on a certain property if they feel they are being discriminated against? How do they go about doing that? And I think that message is for you, Michelle.
Yes, absolutely. Yeah, I should have mentioned that. We absolutely take tips. We have a complaint form for anonymous tips on our website. You can call our office and just say, look, this has been happening. I've seen, I have clients that's been happening to, or it's been happening to me. I don't want to get involved, but here's the name of the property, and we can absolutely test.
Sounds good. No, that's good because there's sometimes where you feel, I know that there's some commercial properties where in a previous position, they're like, we're looking to, work, we're looking to start a business. And when we called, we had an accent. The person said that it was no longer available. And then we had someone else without an accent call and they said, yeah, let's set up a time. So it's good to know that you, have the ability to be able to do that, especially anonymously. So that's perfect.
Yeah, thanks.
The next one that we have in here was, how do they apply for your services? And that will go for Sarah and for Michelle. So we could probably start with Sarah really quick. Somebody wants to go to LSNM. What are the best ways to apply?
The best ways we can do applications over the phone. And I can, or Crystal can put our contact information in the chat with our phone numbers. We have an 800 number. People can also so they can apply that way. It takes about 15 minutes over the phone. And when you do that, you're connected almost all the time, connected with an attorney right away. If you're eligible, you can do an online application on our website, or you can stop into one of our offices between 9 and 3, Monday through Friday, and do an application. Our program is based on household income and asset eligibility. So we do have to go through that financial screening process, but we try to make it as simple as possible. So I would, so again, phone call, online, or in person.
Perfect. Thank you for that. And then Michelle, did you have any particular, is it mostly that they are going to call in or go onto your website if they needed to file something for discrimination?
Yep. So they can, either way, there's a complaint form on our website, or they can call in. We are not income bound, so it can be any income. And yeah, there's no real, there's no real formal, they just call in, like I said, with the advocacy, they call in, we talk to them. If it seems to be a fair housing complaint, we can work with them. If it's a landlord tenant issue, then we have to, forward it out. That's where legal services comes in, because it's, awesome that they have they have a big round, we're only focused on the Fair Housing Act, but legal services has kind of a broader way of looking at the law, the housing law.
Perfect. No, thank you for that. Do we have any other questions? I'm just scanning the chat And it looks like the chat is okay. And on our other questions link, it looks like nothing else has come in. So I'm going to go ahead and share my screen really quick. Oh, but before I do that, I have a little poll. I'm going to try this out. Didn't try it out last time, so hopefully this works. If it doesn't, we'll move on. No problem. But this is community choice, because what I like to do is I want to make sure that we are hitting the topics that you want to hear. As a community engagement and outreach coordinator, I go out in our 22 counties to try to talk to our community partners, our community organizations, to see what issues are their clients having and how can we best serve them. But we also want to hear from the people that are coming to our presentations that maybe I haven't talked to yet. So this is a community choice poll, and I hope that it's popped up if you guys can see it. And basically, it's what other topics would you like for us to cover? So if you guys take 2 seconds to fill out our poll, that would be great. And I don't know if you guys can see exactly, you know, who's been or how many are on there, but we're just going to give a couple of minutes here for people to kind of chime in, because it's really important that I be able to get these educational opportunities for everybody. And you guys are chiming in pretty fast, so that's pretty nice. I like that. We'll take 1 more minute for that, and then we'll go ahead and get the information for all of our panelists out there for you too. Wow, we have a lot of people that want protective orders. That's really great. That might have to be one of our next ones coming up. Speaking of coming up, we have the legal table. It is every 3rd Tuesday of the month. So always make sure to join us. If you want to become a presenter, please let me know. I will go ahead and let's see, we're going to share the results here. Perfect. Can you guys see the results for the poll?
Oh.
All right. That's good. We have protective orders. We have senior issues, family law. All right. Thank you guys for giving me some direction as to what you guys want to hear. It's really important. I'm going to make sure to save these so that I can go back and make sure we have some educational opportunities on that. And I'm going to share my screen also so that if you do want to become a presenter, feel free to email me at cjamerson@lsnmlaw.org, or you can give me a phone call at 218-422-7034. If you happen to have your smartphone, feel free to take a picture of the QR code. And if you'd like just to book some time to talk with me or a Zoom call about your organization, you can definitely do that as well. Other than that, I want to make sure that I get the information for all of our panelists out here. Here we go. So we have the LSNM, High Plains Fair Housing and Legal Services State Support. I want to thank all of our panelists today. And I'm always talking.
I was going to say that's
talking too much. Go ahead, Michelle. What? Thank you so much for everybody.
I was just going to say, but you already passed it. That was not our website.
Oh
no.
Okay. Please put your website in the chat. I do apologize if I have the wrong site in there. We'll get the right one in there.
There it is in the chat.
Perfect. Sorry about that, Michelle. All righty. Well, thank you everybody for joining us at the legal table. Please join us on the 3rd Tuesday of next month when we're going to be talking about unmarried parenting rights. And then we will have one of our LSNM attorneys and 2 other community partners come and speak with you about all that. Until then, have a wonderful afternoon.
Thanks, Crystal.
Thank you, guys.
Bye-bye.
Bye.